Typically speaking, I don't want to go too much in the weeds here. The government can always grant immunity to get the testimony of a witness, but not the defense. I actually argued a case like this where I felt that the court should have granted immunity, but the cop in that particular case stood behind the Fifth Amendment, so his testimony was prohibited from me getting it, and I felt that that was an unfair thing. To the second point where they're arguing it's hearsay, hearsay is an out-of-court statement used to prove the truth of the statement. The defense may not be offering this for the truth of the statement at all, but to the credibility of the witnesses and the individuals who are responsible for the investigation. So it may have an ulterior purpose other than saying that the statements themselves are in fact truthful statements. So obviously, like you said, Michael, we don't know what's in there. The defense wants it in. I, as a prosecutor, personally, again, I go back to something I've told you guys a million times, never lost a murder case, never got reversed on appeal, because I never stopped the defense from introducing evidence unless it was wildly out of proportion, because I wanted them to have every opportunity and to blunt the argument on appeal that they were denied an opportunity to present something to the jury that would have been relevant.
And Bob, I just want to say, and we literally just got the paperwork earlier in this afternoon, the Commonwealth is claiming that what's in there is being used for the truth of the matter asserted, whatever's written. And again, I don't know exactly what that is, but they're claiming it is. That doesn't mean it is.
Right.
That's often the argument, but that's what they're claiming.
And what's interesting to your point, Bob, is I have not heard the Commonwealth is asserting that it's not relevant, but rather that it's hearsay. And so to me that says there may, wait, go ahead, Bob. There may be a pretty good argument that it's relevant.
Yeah, I want to be really careful because I know that you guys have such a fan base of true crime aficionados and legal scholars. The hearsay rule is what I said, but there's also, Judge Michael, you know, like 1,000 exceptions to the hearsay rule. So, you know, there are these exceptions where the court has essentially said, when an individual makes a statement, even though it's hearsay, it's inherently reliable. For example, a statement that you would make to a doctor for purposes of diagnosis. We're going to allow that, even though it's hearsay, to be admitted because it's inherently reliable. So let's watch out for the defense who's going to try, if it is hearsay and they are using it for the truth of the matter, if they're going to try to find an exception. And in every state law also is that Rubicon, that's a safety valve that says, or otherwise in the interest of justice. So the judge has a tremendous amount of discretion as to whether they're going to admit this or not. And again, for me as a prosecutor, I don't have an appetite for denying the defense information based on sophisticated legal arguments, because they can go wrong and that can cause a reversal of your case down the road.